My name is Daniel Mercer. That's the name on the patent. That's the name on the employment agreement. And that's the name on the clause that nobody bothered to read until it was too late. I spent 26 years as the head of pharmaceutical R&D at Hargrove Biosciences. 26 years of 5 a.m. mornings, missed anniversaries, and a lower back that never fully recovered from the lab stools. My wife Linda will tell you I loved that work more than was healthy for any man. She's probably right, but when you're standing at the edge of something that could change how people live, a compound that actually works, a delivery mechanism nobody else has cracked, you don't clock out at 5. You don't clock out at all. I joined Hargrove when it was still operating out of a converted warehouse in Columbus, Ohio. 43 employees, 2 functional lab stations. The founder, a man named Gerald Hargrove, used to make coffee himself every morning and leave a cup on everyone's desk before they arrived. He shook your hand and remembered your kids' names. He was the kind of man you'd walk through fire for, and I did, more times than I can count. Over 2.5 decades, I helped build Hargrove Biosciences into a company worth nearly $400 million. The crown jewel was a drug delivery platform I developed over 7 years, a time-release polymer mechanism that could be licensed across multiple drug categories. Every major pharmaceutical company in the country wanted access to it. We called it the Meridian platform internally. To the outside world, it was the reason Hargrove was suddenly worth acquiring. Gerald retired 4 years ago. I understood. He was 71, his knees were shot, and he'd earned every moment of the quiet life he was heading into. What I didn't fully understand at the time was what it would mean when control passed to his son-in-law. His name was Preston Vale. He'd married Gerald's daughter, Olivia, 11 years earlier, at a ceremony I attended somewhere in the Hamptons. Preston had the kind of smile that arrived before the rest of his face did. He wore his suits like armor and spoke in the cadence of someone who'd taken one too many executive leadership seminars. He had an MBA from a school I won't name, and exactly 0 days of experience in pharmaceutical science. Gerald named him CEO anyway. Family business. His daughter's husband. I told myself I could work with it. For the first year, Preston mostly stayed out of the labs. He focused on restructuring the commercial side, which meant firing 3 people in marketing who'd been with us for over a decade and replacing them with a team of consultants who charged more per hour than most of our scientists earned in a month. I kept my head down. The work was what mattered. Then Caelum Pharmaceuticals entered the picture. Caelum was a mid-size firm out of San Diego, well-funded, aggressive, and strategically positioned to go public within 18 months. They wanted the Meridian platform, not just a license. They wanted to acquire Hargrove outright, bring the entire R&D team under their umbrella, and use the platform as the cornerstone of their IPO. The deal on the table was $380 million. I was the key to that deal. Everyone in the room knew it. The platform lived in my head, in my notebooks, in 26 years of institutional knowledge that couldn't simply be transferred in the file share. Caelum's due diligence team spent 3 weeks with me specifically. Their lead science officer told Preston directly, Daniel Mercer is non-negotiable. He stays, or the valuation drops significantly. Preston smiled his front-of-face smile and said, of course. The deal was set to close on a Friday. 48 hours before closing, I was scheduled to receive a performance bonus of $112,000, a payout I'd deferred twice over the past 3 years at the company's request during tighter quarters. That bonus had a clause attached to it, one that Gerald himself had insisted on years earlier as a way of protecting me. The clause stated that upon payment of the deferred bonus, full co-ownership of the Meridian platform IP would be transferred to me jointly, meaning any acquisition of the platform would require my explicit written consent. Gerald had added it as a form of loyalty insurance. His words to me when we signed it were simple. I want you to know this company can never walk away from you, Daniel, not without you walking first. I don't think Preston ever read that agreement carefully. I don't think he thought he needed to. On Wednesday morning, 51 hours before the bonus was scheduled to hit my account, Preston called me into his office. His assistant, a young woman who always looked faintly apologetic, closed the door behind me. Preston was standing at the window with his back to me, which I later realized was a practice thing. Something he'd probably seen in a movie about power. He told me the company was moving in a new direction with its leadership structure. He told me my contributions had been immeasurable and that he had the utmost respect for my career. He told me they were right-sizing the executive team ahead of the transition. Then he told me my position was being eliminated, effective immediately. I didn't say anything for a long moment. I looked at the back of his head. I thought about the warehouse in Columbus. I thought about the coffee Gerald used to leave on my desk. I thought about the 7 years I spent developing a platform that was now the reason this man's family was about to clear nearly $400 million. I asked if this was effective immediately. He said yes. I asked about the bonus. He said the bonus was tied to active employment status and that since my position was being eliminated today, I would not qualify for the payout. He finally turned around when he said that. He was watching my face, I think, for some sign of collapse, something that would let him feel like he'd won cleanly. I nodded slowly. I told him I understood. I asked if I could have 30 minutes to collect my personal belongings from the lab. He said, of course. I did not spend that 30 minutes collecting belongings. I spent it in the lab with my phone, photographing 3 specific documents from my personal files I had always kept in both my office and a secured off-site location. The first was my original employment agreement with Gerald's signature. The second was the bonus deferral paperwork, signed by Preston himself 2 years prior, which contained the full clause language. The third was a legal opinion I'd quietly requested from an outside attorney 8 months earlier, when I'd first started sensing something shift in the way Preston spoke about the transition. The outside attorney's opinion was clear. The clause was enforceable. If the bonus was not paid, the IP co-ownership did not transfer. But if the company attempted to acquire or transfer the Meridian platform to any third party without my co-ownership consent and without having fulfilled the bonus obligation, the transfer would be legally contestable. I had asked that attorney as a follow-up, what would happen to an acquisition that closed without resolving a contested IP ownership claim? Her answer was 3 words. It would unravel. I walked out of Hargrove Biosciences at 11:17 a.m. on a Wednesday. I drove home. Linda was in the kitchen when I walked in. She looked at my face and didn't ask any questions. She just poured me a cup of coffee and sat down across from me at the table, and we sat there together for a while. That afternoon, I called the outside attorney. I told her what had happened. She listened without interrupting. When I finished, she was quiet for a moment. Then she said, "Daniel, I think you need to call Caelum's legal team directly." I told her I wasn't sure that was appropriate. She said, "You have a legally cognizable claim to co-ownership of the asset at the center of their acquisition. You're not doing anything inappropriate by informing them of that claim. In fact, failing to do so could be considered a problem for everyone involved." I asked her what I should say. She said to let her draft the letter. It would go out Thursday morning, less than 24 hours before the deal was scheduled to close. The letter was precise and factual. It did not threaten anyone. It did not contain emotional language. It simply outlined the clause, the timeline of events, the failure to fulfill the bonus obligation prior to termination, and the resulting contested status of the IP co-ownership. It was addressed to Caelum's general counsel and copied to their CEO. I want to be clear about something. I did not send that letter to blow up the deal. I sent it because I had a legal obligation to disclose a material claim, and because 26 years of my life were sitting inside that platform, and I was not going to let it be handed off without anyone knowing my name was on it. What happened next happened fast. Thursday afternoon, Caelum's general counsel called my attorney. The call lasted 40 minutes. By the end of it, Caelum had formally requested a 72-hour pause on closing to conduct additional due diligence on the IP ownership chain. Preston called my cell phone at 6:14 p.m. that same evening. I let it go to voicemail. The voicemail was 40 seconds long, and the first 20 of them were silence. When he finally spoke, his voice had lost the seminar cadence entirely. He asked what I had told him. He said the word Daniel in a way that was almost unrecognizable, like something had been removed from the middle of it. I did not call him back. My attorney called me at 8:30 Friday morning. She told me Caelum's team had reviewed the clause and confirmed its enforceability with their own outside counsel. They had gone back to Preston with 2 options: either cure the breach by paying the bonus and honoring the co-ownership clause, or face a significantly restructured deal with a substantially reduced valuation to account for the contested IP risk. Preston tried to argue the termination had voided the contract. Caelum's counsel disagreed. There is a principle in contract law. I am not an attorney and I will not pretend to explain it with precision. But the general idea is that you cannot structure a termination to specifically avoid a financial obligation that was already vested in its triggering condition. The bonus had been deferred with explicit documentation. The platform's value had been established. The timing was not a coincidence, and Caelum's lawyers were very good at their jobs. By Friday afternoon, Caelum had withdrawn from the deal entirely. Not paused. Withdrawn. Their CEO issued a brief statement about unresolved due diligence matters. The industry press picked it up by end of day. Within 48 hours, 2 other potential acquirers who had been watching the Hargrove process quietly stepped back as well. Nobody wants to be the second buyer into a contested IP situation when the first buyer just walked out. I heard through a former colleague that the following Monday was not a pleasant day at Hargrove Biosciences. I heard that Preston spent most of it on the phone with Gerald, who had apparently not been told about my termination before it happened. I heard that Olivia, Gerald's daughter, had not been particularly warm to her husband that weekend. I didn't take pleasure in any of that. I want to be honest about that. There's a version of this story where I felt triumphant, where I savored every detail of the fallout, but mostly what I felt was tired. 26 years of tired and something that felt almost like grief, for the company Gerald had built, for the work we'd done together, for the version of Hargrove that still had his handwriting on it. 3 weeks later, Preston's attorney reached out to my attorney with a settlement proposal. They offered to reinstate my bonus and add a separation payment if I would sign a release and provide written consent for a restructured acquisition process. My attorney asked me what I wanted to do. I told her I wanted the bonus paid. Not as a settlement, but as a fulfillment of the original contract. No release, no conditions beyond what the original agreement specified. If Preston wanted to restart acquisition conversations with a clear IP chain, that was available to him, but I was not going to sign away my right to be treated fairly in exchange for money I was already legally owed. It took 6 weeks of back and forth. In the end, the bonus was paid. The co-ownership clause was formally executed. A smaller deal, ultimately with a regional biotech firm rather than Caelum, was negotiated over the following months at a substantially lower valuation. I wasn't present for any of those negotiations. I had no desire to be. By the time the final paperwork was signed, Linda and I were on a long weekend in the Blue Ridge Mountains. It was a Tuesday. I remember that specifically because I kept thinking I'd never taken a Tuesday off before in my adult life. Not once. And here I was, sitting on a porch in the mountains with a cup of coffee and my wife and absolutely nowhere to be. She asked me if I was going to look for another position. I told her I had a few conversations to consider. Caelum's chief science officer, of all people, had reached out personally after the deal collapsed. He told me he'd read my published research going back 15 years, and that if I ever wanted to talk about a consulting arrangement, his door was open. There were 2 other firms as well. The platform's visibility during the acquisition process had, paradoxically, made me more visible. But that Tuesday, on that porch, none of it felt urgent. Linda asked me what I actually wanted. I thought about it for a while. The mountains were doing that thing. Mountains do in the evening when the light starts to flatten and everything gets very still. I told her I wanted to teach for a while. I'd been approached by a university in the Mid-Atlantic region about joining their pharmaceutical sciences program as an adjunct. Then, possibly, in a more permanent capacity. I liked the idea of the work living forward, of it being in someone else's hands eventually. Good hands that had been trained carefully. She said she thought that sounded right. I thought it sounded right too. There's something I've been thinking about since all of this happened. I worked for 26 years for a company I believed in, and I built something real there, something that will be used in drug delivery research for decades, regardless of who owns the paperwork. Preston couldn't take that. The termination couldn't take it. The failed acquisition couldn't take it. The work existed before the clause, and it will exist long after the lawyers have moved on to the next deal. Gerald called me about 2 months after everything settled. He'd heard the whole story by then, or most of it. He was quiet on the phone for a long time. Then he said he was sorry. Not for himself. I don't think Gerald had much to do with what Preston decided, but the kind of sorry that means. I built something and I should have been more careful about who I handed it to. I told him it was all right. I told him the work was intact. He asked how Linda was doing. I told him she was fine. Better than fine. She'd started a garden that spring that was, according to her, going to produce enough tomatoes to outlast us both. He laughed. It was the same laugh I remembered from the warehouse, from the early mornings, from the years before any of this got complicated. I told him to take care of himself. He said he would. I meant it when I said I'm fine. I said it to Gerald, and I'll say it here. Not fine in the way people say when they mean the opposite. Fine in the way that means, I know what I built, I know what it cost, and I know it wasn't taken from me. What Preston tried to do was use a termination to erase a name from something it didn't belong off of. He didn't succeed. The clause held. The record held. My name is Daniel Mercer. It's on the patent. It's on the agreement. And it's on the work. The real work. The kind that doesn't disappear when someone decides your position has been eliminated. That's the part they never account for. You can eliminate the position. You can pull the offer, move the date, restructure the terms. But the work already happened. 26 years of it. And no amount of corner office maneuvering changes what's already been done. Linda's tomatoes, by the way, were extraordinary that fall. She was right about all of it.